Good afternoon, and welcome to today's webinar. We're Vann attorneys, and we practice law in North Carolina. My name is James Vann. We're going to be talking today about business contract terms and conditions and whether or not you can use those or how would you use those either as a shield or a sword. So hopefully you will enjoy this today. If you have questions, as many of you know, you can submit those two different ways. One is using the control panel on your GoToMeeting interface there on your screen. You can submit a question that way, or you can email it to webinar@vannattorneys.com. And would love to have your questions because, quite frankly, that helps us and would guarantee that probably someone else has a similar type question. A little bit of housekeeping before we get any further. On September 15th, we're going to be hosting a webinar at 3 o'clock, and we're going to be talking about drone or unmanned aircraft systems, the current legal update for that. Many of the companies I know that we do work for, some of you have already purchased drones, unmanned aircraft. We're going to be talking about the current law, what's happening, and where we're heading to with that. So hopefully you'll be able to join us. Hopefully that'll be interesting to you. And for you who want to buy a pizza by using a drone, you have to wait a little bit longer, I believe. All right, let's look at some contract terms and conditions. And how do we use those? Are you going to use those for your protection, or do you use those as a shield? And it really depends on who drafts the contract. And so, in many of you, y'all have contracts that you look at all the time. You certainly have contracts that your company may generate, and you'll get a lot of contracts coming in from your customers and from your vendors. So a lot of times what we're going to be doing today is we're not going to be looking at specific provisions in that we're going to look at the language of the provision, but we're going to talk about the topics because I think that'll be helpful to you. In reality, we could look at probably 100 or 50 actual provisions of each of these topics, and I'm not sure that it would be that helpful to you because you could change one sentence and the whole meaning could change. So the first topic we're going to be looking at is time is of the essence. And so what that really means is it's a contractual term that indicates that the parties that are agreeing to this contract, whatever it is, intend for the parties to perform at a certain time or pursuant to a certain time frame. So a lot of times you'll see it if it's a contract, someone wants to buy a product or service, and you need to have one of those parties perform by a certain date. So that could certainly be used to your advantage. If you need the product or the service, you could say time is of the essence. I want to buy this material, or I want to buy this product, or I want these services, and I need to have that by no later than December 31st, and time is of the essence. What you're saying in that sense is that is a material term of the contract. So typically, if you said, I need this service or product by December 31, and if I don't have it, then this is what happens. So if you're using it as a sword, it's because you absolutely need it. If it's a shield, obviously it's like, hey, look, I may not be able to perform that. So I know many of you get purchase orders from customers, and it says time is of the essence. And the reason I know that is I've read quite a few of those this year, where it says time is of the essence. I want to buy this material. You're going to be, as a supplier, providing those materials and supplies, and time is of the essence. We need to have this within a particular time frame. Well, some of you don't have the materials in stock. It might be coming from a manufacturer. It might be specially manufactured goods, and so you don't have any control on whether or not it's the turnaround time for that. So just to make sure that you be really careful with that. And again, the issue is that there are damages. What would be the damages if it went beyond the time frame? In some contracts, the damages could be, hey, look, I told you I needed it by December 31. You delivered January 20th. That has caused us, substantial delay damages of what we were trying to accomplish. So you could be getting into, delay damages. You could be getting into actual damages of if they then had a contract where they were required to use those materials or services and you didn't give it to them in time. So really be careful with that and just sort of look at it. So I hope that helps. Again, time is of the essence is not it's a pretty common term, depending on the contract. And a lot of times you'll see time is of the essence possibly in real estate. If you're buying a house, sometimes people will say time is of the essence. So again, make sure that you think about that a little bit and read that contract. If you have questions, let us know. We'll be glad to help you with it. Many of you also run into provisions that call for arbitration or mediation. Again, a very common term, alternative dispute resolution is what some people will call it. They can be very, very helpful. But also, I would encourage you to make sure that you know what you're doing. There's one of our clients who they've really ramped up in their sales, are getting some really difficult contracts from their customers. Many of those are boilerplate contracts that I really wonder even if the other side knows what they're asking for, but they will ask for binding arbitration, and the arbitration might be in another state somewhere. So again, really look at that, and again, think about it from your perspective. If you're using that in your contract, do you want it to say arbitration? I know I've read some of our clients' contracts recently, and it had an arbitration provision in there only because someone years ago said we ought to have it in there. My advice typically, again, it may be depending upon your business and what you're doing and the specific contract, but from a business perspective, you really want to be careful if you're requiring binding arbitration. And the reason I say that is this: arbitration back 15, 20 years ago became a lot more commonplace and more popular because it was faster and at the time less expensive than court. I really believe lately that arbitration has become as costly and not any faster than court in of itself. So you really want to look through that. And arbitration is really what it is. It's a mini trial. It's just not in the court system. Some people talk about AAA, which is the American Arbitration Association, about using their rules. Certainly that's one area that you could use. There's also rules, arbitration rules of North Carolina that someone could use. But give that some real thought. And so, but if you're signing a contract from your customer or someone who is trying to buy products or services from you, and they have a mandatory arbitration clause, really give that some thought. We had a client that happened to about a year and a half ago. Our client did not get paid. We filed suit, and sure enough, there's an arbitration clause in there that says that all disputes would be resolved by way of arbitration. So we're trying to figure out how to handle it. The difficult part of that was it was in a state that was not anywhere close to our client, and their costs just went dramatically up because of that. So they have to stop and really give that some consideration. My advice to most of our clients, and again, it really needs to be specifically looked at, but mediation is a wonderful way of having alternative dispute resolution. And the reason I like that is it leaves the business owners and the business-minded people in charge of working out any differences or disputes, whereas arbitration has the parties would choose or select an arbitrator, and then the arbitrator listens to both sides and makes a decision. With mediation, the business parties, hopefully, are using their business brains to try to decide how the case or the dispute should be resolved. And then if it settles, it settles. If it doesn't, it proceeds forward. So mediation is a really good alternative for resolving disputes. But what about integration provisions? Many of you have probably seen a integration contract clause in a contract, and you may know what it's about, you may not. Typically, the integration terms provide that when there's a written contract, that is the final agreement between the parties, and no other documents can come in that were drafted ahead of that or before that to explain the agreement. So let's say, for example, that there was an email chain back and forth on contract terms, but when the contract became it became time to sign it and agree to it, there's an integration clause that says all previous conversations and negotiations are now integrated into this document. What that really means is you can't go back later and go, well, yeah, but the person I entered into this contract with said they were going to do the following, and I was still counting on that. Well, the integration clause is designed to say can't do that. There are some ways around that, but they're not as, it gets pretty tight. So if there is an integration clause, you really want to make sure that everything is in the contract the way it's supposed to be. So again, think about how that helps you or hurts you, depending on where you would want to have that in your contract or not. We've had cases where integration clauses are included, and we need to rely on some documents to define the terms, and so sometimes it can get tough about how you figure out how to get that in and get that to be included in the conversation of what the terms should be. Again, typically it says that they're not in the final contract, so terms are not to be relied on. So again, think about that. We talked about this just a little bit earlier about the choice of law when I said we had a client recently who had a provision about arbitration, and that arbitration clause said that any and all disputes would be resolved by arbitration, and it chose a state that was not anywhere nearby for our client. So having a choice of law in your contract, I know many of you have North Carolina because most of you have businesses in North Carolina, or it may say Virginia, depending on where your corporate office is. But if you're dealing with your customers or your vendors and they send something in as a purchase order or contract and it has a state law that's different than yours, you really want to give that some consideration. Sometimes you think, you know what, it's not worth the fight, I'll accept it. Other times you think, no, the risk is too great, I can't do that. And also, you have no idea what that state law is necessarily if you're not doing business there on a routine basis. So it's sort of difficult to figure out if it says, the law of state of, Kentucky or Michigan or wherever it may be. If you've never done work there or not familiar with those laws, you really don't know. We had that happen to a client a number of years ago, dealing in some software issues, and they had to go, I think it was Kentucky, and it was not a pleasant experience for them because they had to hire counsel there. They had to go back and forth quite a few times, actually a lot of times, and it just didn't work out to their advantage for several reasons. But so be really careful. If the contract provides for a specific state law, then that law might be the one that's got to be used. So it could be that all disputes are handled in another state, or it could be that they say that this specific state, the law is applied in this case. So again, not only is the case going to be heard there, but the law of that state would apply as well. Again, think about where the parties are located. If you're here in North Carolina and your customer's here, but they also have an office, say in, say Louisiana or somewhere else, all of a sudden you think, wait a minute, I'm here, my customer's here, but they have their corporate office in Louisiana. Am I going to have to go to Louisiana to resolve this if we have a dispute? Again, look at that contract. Where is the contract to be performed? Again, just something else for some consideration. That one I was telling you about earlier where there was an arbitration clause that said the Kentucky law applied, everything was here in North Carolina except for our client's customer. They happened to be out of Kentucky, but for the most part, everything else was done here. And my argument is, well, what makes sense? It makes sense to have it in North Carolina because the project's here, our client's here, the other side have people here who were involved. Otherwise, everybody's got to travel to Kentucky. They're going to probably use that, they meaning the other side, for their advantage to say, yeah, we're just going to make y'all travel and increase the cost. So, again, look at the choice of law provision and look at your own contracts to make sure if you probably have those in there. I know many of you do, and see if that makes sense. And sort of the same thing with this jurisdiction. Where if there's going to be a dispute, if there is a dispute, where is that lawsuit going to be filed? We sort of talked about that just a moment ago, but jurisdiction and venue sort of typically go hand in hand. Where the party is located, where's the contract going to be performed, and so forth. What makes sense? So those two sort of go hand in hand. What about payment for goods? And I know many of y'all have a great contract that starts off with a credit application or some contract that defines your payment for goods. Make sure that it's clear. And I know, I don't know about you, but if you read something 100 times over, you think, well, that makes sense. Have somebody else read it to see if they read it differently. It's amazing how many times we get a contract from a client or a credit application, and we read it differently than the client does. That's not to say that one is right or wrong, but the client has been dealing with that contract language for an extended period of time. They think it says one thing, we happen to see it, and we think it says something else, or either someone else sees it and they think it means something entirely different. So make sure that it's clear. And one thing I would encourage is to make sure that your credit application, your contract, your invoices, your billing statements, your delivery statements, whatever the documents are that you use, make sure that all of those are consistent with the payment for payment terms for goods and supplies or services. So what about pay if paid provisions? And again, the next two talk about really in the construction setting, outside the construction setting. So for those of you who are not in the construction setting, pay if paid clauses are fairly common in the construction trade. It says that the customer will pay their vendor when they get paid, or one sub says to the other, "I'll pay you if I get paid." Pay if paid in North Carolina is unenforceable, invalid. There's a section of the North Carolina General Statutes that addresses when subcontractors should be paid. So if paid is unenforceable, as pay when paid is as well. Even if it's in writing, you can say that's unenforceable, not doing that. But if I were you, if you see that kind of language, I'd be really careful to accept it. You, most of the people on this conversation today, have a contract provision that says I should be paid in 30 days. You're not banking on getting paid based upon your customer getting paid. And so I would be really careful if you see a purchase order that has that, strike it out. Try not to let that get by. So pay if paid and pay when paid in North Carolina, unenforceable, even if it's in writing, but you don't want to have that argument that, in fact, that someone says, well, that's in the contract. Well, it's unenforceable. What about conditional payment terms? That is, I'll pay you condition upon the following. And you got to look to see what that term is. It could be, if you get a purchase order, I'll pay you conditional upon acceptance of the materials by the customer. No, don't do that. Be really careful about looking at conditional payment terms, because you can sit there and really create a real problem for proving that those conditions have been met. And the other one is, sometimes you'll see somebody will claim a right to offset or reduction, either if they say, for example, well on another contract, we're working on, you owe me $10,000, but on this I know I owe you 20, so I'm just going to deduct that 10. But that other 10, you may have a reason not paying them on that, or it may not be due yet. So really be careful with the provisions that someone may try to put in that call for a right of offset or right of reduction. And again, if you want to use that for your own benefit, that is, hey, look, we have multiple relationships contractually, and I want to be able to use the right to offset or right to reduce what I owe you based off of some other contracts that we have going on. that might be a benefit to you. But certainly you don't want that to come into play with what you're doing. Another very popular provision is indemnification, and generally what that means is when the purpose of it is to compensate somebody or another if there's some kind of harm, damage, or loss. We were involved in a merger acquisition not too long ago, and these kinds of provisions are almost always in every contract. And the one thing that I would tell you that I heard another lawyer in this conversation say is that generally indemnification agreements is where lawyers spend lots of time pushing the envelope back and forth, trying to get the other parties to indemnify their client. But in reality, what they're doing is they're wasting time, because the time when you actually call on that provision is so seldom. And I thought that's an interesting analysis by that attorney, one that I don't necessarily disagree with. But it happens like this: if you think about a kid running down the sidewalk and they're running really hard and really fast, they may not fall and bust up their knee. However, if they do fall and bust up their knee, it's probably going to be a pretty good bust up. So you don't want to blow through these indemnification provisions, because I'll tell you, you could lose the farm if you're not careful with these provisions. But the chances, the times when they actually are implemented are much seldom compared to how many times they're involved in contracts. So hopefully that helps. The reason I say that to you is this: sometimes pay attention to the weeds. You don't need to stay in them the whole time, but make sure you read those. And if it doesn't make sense, get somebody else to read it. Ask us, we'll read it to see if we can help you. But indemnification agreements, you certainly want to be indemnified, but by people you're contracting with, and they want you to indemnify them as well. These provisions are very broadly used, and they can differ. I mean, literally, you could change 2 or 3 different words, and the whole meaning could change. So be really careful. Don't say, "Oh yeah, I've seen that provision before," and blow through it. Really slow down and read that when you get to it. What about assignment or subcontracting? A lot of times you might see a provision in a contract that says that the parties cannot assign their rights or obligations under the contract. You think, well, why in the world would anybody ever do that? You can assign a contractual right. That is, for example, let's just say that you and I enter into a contract where I'm going to do X for you, and me doing X is not something that's so specialized that I'm the only one that could do it. But after I enter the contract, and we don't have a provision in our contract that addresses assignment, and I find out that for some reason either I can't do it, or I don't want to do it, or whatever reason, I think, you know what, I've got a friend, I'm going to assign this contract to my friend, let him do X, whatever that X is. Well, you may think, wait a minute, I don't want James's friend to do it, I want James to do it. If there's not an assignment clause that prohibits that, I have the right probably to do that. So it generally prevents a party or parties from transferring the agreement from one to another. So again, really make sure. Sometimes you need to know if it could be very relevant. Other times it may not be that relevant to you, but you probably want to make sure that it's included in there. Also, limit of liability. I know a lot of y'all look at documents all the time and contracts, and certainly everybody's looking at it from a cost standpoint, a liability standpoint, what's the risk standpoint. Hopefully the profit margin is good for you as well. But generally looking at the attempts to limit the liability of the parties in the contract is really what people are trying to get to. They'll say, I'm not going to be held for, say, actual damage or incidental or consequential. You sort of pick that out. We've had clients before that are distributors or vendors, suppliers, and they have a contract, and all of a sudden you don't get paid, so you file suit, and all of a sudden you get a counterclaim, and they say, but hold on, you can't. The reason you get sued is because there was, say, maybe a time is of the essence. And they go, you didn't perform timely, or you cost me the way the transaction happened. if the customer says you cost me actual damages because I couldn't perform over here for whatever reason, well, if you want to have that limitation of liability in your contracts, I'm not accepting that. I'm not willing to accept that. So you make sure that you're thinking about that as well. So just think through that a little bit. We got a really good question that just came in a minute ago. It says, do you happen to know how many states have made pay if paid or pay when clauses illegal? I do not, but I'll tell you what I'll do. I'll work on finding it. I'll see if I can find it. There used to be, I'm trying to think through this, either the AGC, I don't know if the AGC keeps up with that or not. I'll see if I can find that and post that back out to those who have attended. Another question we just got was, would you recommend separate credit applications for services versus products? And yeah, I don't know that I would. The terms could be different in that between the services and the products. So it's possible that it might be necessary, but it really depends on what the terms look like. I know some of y'all that are on the webinar today do turnkey installation of certain services. That you probably would need a separate contract. It really probably depends on what industry you're in. So I'm sorry I can't specifically answer that. I'm just sort of thinking off the top of my head. It probably depends more on what your business model is and how you bill for it, what work you're doing. And then there was another question we just got. Would a restriction on assignment of credit rights extend our ability to send the debt to collections? No, because what you're doing there, you're not assigning the rights. If you're sending it to collections, you are having someone collect for you. You're not assigning the debt, if you will. There could be provisions where you transfer the debt and get paid for it, and somebody else has got to collect it. I don't think many people do that too much. Certainly not for those who are participating today. But would a restriction on assignment of the credit rights extend to your ability to send it to collections? I do not think it would. So anyway, those are some great questions. Thank you all for sending those in. Again, if you have any other questions, let us know. We'd be glad to answer those. One more thing on the limit of liability is it can be limited to compensation under the contract or limit of values. For example, I've seen a lot of contracts lately where it'll say, it has to do with a particular building, and the landlord is involved in the building. It'll say, especially under lease agreements, you'll see this a lot, commercial lease agreements, that if the tenant has a right to sue the landlord for any reason, that the limit of liability is limited to the value or the asset value of the building that they're in, not any other assets. So when we're representing tenants and we see that kind of language in there, we think, wait a minute, let's just say, for example, the landlord does something really, really egregious to the tenant, and just say the building burns down or something too. I mean, all of a sudden the building that the tenant was in now is worth zero. The dirt is worth something, but the building is worth zero. If that was in there, our tenant sued them and won, then we're limited to the value of the dirt, not the building. So we try to strike that out, because if it's something that's really egregious and it kills the tenant's business, you're limiting your liability. Again, the chances of that happening are probably pretty low, but it really depends on the circumstances. Or it could say that just a straight out contract. Let's just say, for example, I want to buy from you $50,000 worth of materials, and there's this limitation of liability where it says, you say in your contract, well, James, the max that you could be held liable for anything would be that $50,000. That is the value of the materials that I bought from you. Again, that might be something that you could use to your advantage, depending upon the circumstances. But if you're on the other side, of course, you don't want to have that in there at all. So again, there's several ways to do that. And what about warranty disclaimers? And I know a lot of you have this in your contracts. And I'll tell you, these things take up space, but they are worth generally the space it takes up and more. For the most part, the warranty disclaimers work so that they can disclaim or limit warranty items. And so if you are a vendor and you are or a distributor, you're supplying materials from a manufacturer, you probably aren't giving any warranty items anyway. You're giving the warranty from the vendor, from the manufacturer, but not your own. But you want to make certain that you disclaim any and all opportunities for warranties so that you're not opening yourself up for claims down the road. We've got a client right now who they've supplied specially manufactured goods. The customer is complaining that the goods don't operate properly. They haven't substantiated that. My guess is that, because that just popped up like 4 months after the fact, 6 months after the fact, is that that's not accurate, and that maybe they over budgeted or overspent on their general budget, and they're trying to get some money back. Well, these are specially manufactured goods. You can't return them, number one. Number two, if they were malfunctioning the way they are, I think we would have heard about that earlier. So you want to make sure that you're really careful with warranty claims. We just got another question that says, if you do not have any signed contracts, what jurisdiction applies? It's a great question. In North Carolina, the law says that the jurisdiction would be, or can be, where the plaintiff resides, where the defendant resides, or where the cause of action arose. I'll explain that. Where the plaintiff resides. Let's say you're the plaintiff. If you are in X county in North Carolina, you could file your lawsuit there in that county in North Carolina. If you are a defendant, let's just say, for example, the defendant lives in, say, Mecklenburg County, you could file it in Mecklenburg County. Or let's just say the contract was entered into, and again, this is a whole other can of worms, but let's just say the contract was entered into in Wake County. Both people were in Wake County, but the project is located in Durham. You could actually file it in Durham County. So it really depends on, if it doesn't say otherwise, you could file it where the plaintiff resides, defendant resides, or the cause of action arose. There was another really good question. It says, are emails legal and binding if you do not have any signed contracts? I'm going to answer that question this way. That's a great question. Emails are binding, yes. Can you create a contract with emails? Yes. Let's say, for example, that, I send you an email and say, I want to buy your car for, $50,000. And you think, sweet, I'll sell James my car for $50,000. So you send me back an email that says, yes, James, I'll sell you my 2015 Suburban for $50,000. And I said, great, I look forward to buying it. And we cover all the terms. I'll buy it on X date, $50,000 in cash, your white 2015 Suburban. Is that a binding contract? Probably, because it sounds like we've got most of the material terms in there. And then you, whatever reason, you say later, go, well, James, you agreed to buy it, and here's the contract, the terms of the contract by email. That can create a binding contract. So yes, you can use emails to do that. Fax, same thing. I'm going to go one step further. There's two pieces of law now. One is federal, one state. It's the Uniform Electronic Transaction Act, also known as UETA or UETA, and then there's the e-Sign Act, which is federal. And in essence, it says this: you don't have to have original contracts anymore. You can do it electronically, which would also include voicemail, because most voicemails now are electronic and can be saved and can be reproduced in their native form. So even though you think, well, I don't think I created a contract because it was all verbal, you actually can. And verbal contracts are enforceable. It's just difficult to prove what the terms are, because unless you have a recording of it, you don't know what the terms are. that everybody's going to say the terms are different. So hopefully that helps to answer that question. So hopefully that helps on warranty claims. All right, this is a freebie, and I appreciate that question because it feeds right into what the next one. I don't know who, I don't have, doesn't matter who sent that in, but thank you for that question. What about written modification? This is a very common provision in most contracts. It says that this agreement, that is the contract, may only be amended or modified by writing executed by both parties. Very common. So that's not a big deal. And it's a good idea. Well, what about if you have an email or text? Say, for example, that you've got your initial credit application or your contract for the products or services, and let's just say that the customer signed it with blue ink, and the reason I would say that is you actually have the original in your hand. And then later, they're dealing with their sales agent or the sales manager, and sales manager sends them an email and says, look, don't worry about paying in 30 days. We don't really enforce that. You just pay us, pay us in 60 or 90, whatever. No big deal. And you think, no, that's wrong because that violates the agreement. The question becomes is whether or not the sales manager, if they wrote that, do they have the authority to change those terms? Do they have the corporate authority to bind the corporation? So the question, that's sort of a slack, I guess, example, but the general gist is this: you can change a binding contract, regardless of how it was entered into. Let's just say it was on paper and ink, but you can change that by email and text because it's defined as a writing and executed. You think, okay, who executed it? Well, the party who it was being charged against wrote it, and the other side accepted it. That then changes the terms. I'll give you a great example. We represented a company that manufactured glass that went on to these large corporate large office building towers. There was a problem with the glass affixing to the building, and it was in another state. The general contractor who was purchasing the glass emailed the sales manager, I think it was right, sales manager for the company who was pretty high up in the company to explain the problem. Sales manager emails back, says, don't worry about it, we'll take care of it. I'm on the way out. I'll be there soon. This happened to me in Washington State. That ended up costing that customer, our client, several millions of dollars because the sales manager emailed and said, we'll take care of it. What does that mean? I don't know. But they define that, and the court defined that is that you'll replace the glass. So be really, really careful in what you say in an email, but also in a text. I never, quite frankly, thought I'd be texting with clients, and I'm sure many of you, and I know it's got to be the case where if you've got people using cell phones in your company that are dealing with customers, I can't imagine that you're not getting texts as well. So someone could change a contract in a text. So be really careful about that. And again, I think that's going to be defined as something that was in writing, executed by both parties. And by virtue of that, the reason that is number one, the UEDA law and the e-sign law. We've talked about that, I know, a couple times over the years, but be really careful about that. And I hope that makes sense. If you have any questions, let me know. Again, if you've got questions, if you want to submit them, that'd be great. We've got another question that says, if the job site or project is in another state, let's see, if the job site project is in another state instead of your home state and there's no signed contract, which state law applies? Great question. That's one of those law school questions. Job site project in another state and there's no signed contract, which state law applies? Wow. Well, for lien claims, it's going to be, and I happen to know this person comes from a construction background. If it's a lien claim or a payment bond claim, it's going to be the state law where that project is located. If it's a breach of contract claim, it could be in your state because you're here, you could use North Carolina law. But if you don't have a contract and there's a lien claim or bond claim, it's going to be the state where that project is located. Hopefully that helps and answers that question. Great question. Hopefully this is helpful to you. If you have specific questions, let us know. We'd be glad to help you. You can email us. You can send it in however you want to, whatever's easier for you, or just call us, whatever's easier. And again, we hopefully this is helpful. We're going to be having another webinar again September 15th. We're going to be talking about drones and unmanned aircraft. Would love for you to sign up. Hopefully that'll be something that's interesting to you. And if you have any questions, let us know. And at the same time, if you want to connect with us on social media, we'd love for you to do that. We're trying very hard to make these educational opportunities for you by putting out content that we hope helps you in your business and makes you more profitable. We appreciate the opportunity and the trust you give us. And also, if you have ideas or topics, suggestions for other webinars, please let us know. We would love to hear from you because we want to make sure that we're sending out the content that's helpful. Hope you all have a great day and look forward to seeing you soon. Thanks so much.